Okay, so have you heard this? Apparently, over half of adults don't even have a will, like at all.
Wow, really?
Yeah, it's kind of wild, right? I mean, think about it. It's everything you've worked for, all your wishes for, like what happens next. It's all just kind of up in the air.
I actually don't really think about it until.
Exactly. And that's why this deep dive is so important. We're going to break down exactly what makes a will actually legally solid. You know, what makes it hold up.
Right, so no one can come in later and say, well, actually.
Exactly. And we've gone through, well, a ton of legal stuff, actual laws, cases, the whole nine yards to figure out what really matters. And of course, we're going to cut through all that legal mumbo jumbo, make it make sense.
Right, so it's actually useful for, well, anyone listening.
Exactly. Whether you're thinking about your own future planning, maybe dealing with family stuff, or just, curious about how the law works, understanding this stuff, it really gives you a leg up.
For sure. It's about knowing your rights, your options.
Totally. So let's dive in straight into the deep end. So, according to all this legal stuff we've been looking at, there are three big things that have to be in place for a will to be valid, like non-negotiable.
The essentials.
Yeah, the core, the
Yeah.
foundation. And we can think of them as the three pillars: capacity, intention, and formalities.
And those all come from.
The Wills Act from 1837.
Wow, that's
Old school, right?
yeah, but still the basis for everything.
Exactly. It's like the OG will rule book.
Yeah.
So without all three of these pillars, a will can be like challenged, maybe even completely thrown out.
High stakes.
Huge stakes. So let's start with pillar number one, capacity. What's the key takeaway here?
Well, when we talk about capacity in the context of wills, we're really talking about testamentary capacity.
Right. So not just like being awake.
Exactly. It's the legal and mental ability that someone has to actually make a will. And importantly, it has to be there right at the moment the will is made.
So like someone could be perfectly fine one day, make a will, and then, I don't know, have some sort of health issue the next day, and it wouldn't matter.
Right. It's all about that specific moment in time.
Okay, got it. So the law has like two main rules when it comes to capacity. First, the person making the will, the legal term is the testator, has to be at least 18 years old.
Yeah, pretty straightforward.
Right. No minors making wills. And second, they have to be of sound mind. But like we were saying, that's not just some general idea. It has a super specific legal meaning.
And that meaning comes from a really important case, Banks v. Goodfellow,
And that was when?
1870.
Wow, so even older than the Wills Act itself.
Right, but it's still like the cornerstone for how we understand sound mind in a legal sense.
Okay, so let's break this down. What exactly does sound mind mean according to Banks v. Goodfellow?
So there are a few key things the testator needs to understand. First, they have to get the nature of what they're doing. Like they understand that they're creating a will, and that means deciding where their stuff goes after they die.
Right, so not just signing some random paper.
Exactly. Second, they need to have a general understanding of what they own. Not like a detailed list, but a sense of the extent of their property.
Okay, so no need to be a walking inventory.
Nope. Third, they got to be able to grasp and appreciate potential claims. People who might reasonably expect to get something, family, for example. Doesn't mean they have to leave them anything, but they need to understand who those folks are.
Right, like acknowledging that those relationships exist.
Exactly. And then finally, there's this really important part. Their decisions about what to do with their stuff, it can't be messed up by a mental disorder.
So any mental health condition that could be impacting their judgment, that's a red flag.
A big one, yeah.
So it's a pretty specific set of mental skills that need to be there right then and there.
Right. All those pieces need to be in place.
Got it. Now, there's also this other law, the Mental Capacity Act of 2025, that our sources keep mentioning. How does that play into all this will stuff?
So the Mental Capacity Act, or MCA, it's kind of like a bigger framework for helping people who might not be able to make decisions for themselves, like in any area of life, not just wills.
Right, so it's broader than just this one specific situation.
Exactly. And while Banks v. Goodfellow gives us the detailed test for wills, the MCA kind of reinforces the idea that people should make their own decisions whenever possible. It's all about empowering people.
Okay, makes sense. So it's like Banks is a specific test for wills, but the MCA is the broader set of guidelines for how we think about capacity in general.
Yeah, that's a good way to put it.
Perfect. And just to emphasize again, because our sources really hammered this home, this capacity, it has to exist right when the will is signed fluctuating capacity, it doesn't matter. It's all about that moment.
The moment of truth?
Exactly. Now, there's also this other thing that's important to remember. If a will is challenged and someone says, hey, this person wasn't of sound mind, then it's the person who's trying to prove the will is valid who has to actually, prove it.
Yeah, it's on them to make the case.
So they might need medical records, expert opinions.
Right, it can get pretty involved.
So, capacity check. Now, let's move on to our second pillar, intention. It's not enough to just have the mental capacity. The person making the will also needs to actually intend to create that specific document as their final wishes.
Right, it has to be a deliberate act.
So how do we figure out intention? We can't read minds.
Well, the law starts with a presumption.
A starting point.
Right. If the testator had capacity, we just talked about that,
Yeah.
and they signed the will after reading it or having it read to them, then the law assumes they meant for it to be their will.
Okay, so there's kind of a built-in assumption that if someone went through all those steps, they probably knew what they were doing.
Exactly. But, and this is important, that presumption isn't always there. Our sources point out some specific situations where it doesn't apply.
Oh, interesting. Like what?
So let's say the person making the will was blind or couldn't read, or maybe someone else signed the will on their behalf. In those cases, we can't just automatically assume they understood and meant for everything in that document to be their wishes.
Right, because there could be some questions about whether they really knew what they were signing.
Exactly. So in those situations, the probate registry, that's the place that handles wills. After someone dies, they're going to want some extra proof.
Makes sense. Okay, how do we know for sure this was what they wanted?
Right. And it's the same deal if there's something fishy going on, what the law calls suspicious circumstances.
Like what?
Well, imagine the main person who benefits from the will, the big inheritor, was also the one who wrote it.
Oh, okay, yeah, that seems kind of...
Suspicious, right?
Yeah, maybe there was some pressure or something.
Exactly. So in those cases, that presumption of intention, it goes out the window. The probate registry is going to want a lot more evidence to be convinced.
Okay, so it's all about making sure everything's above board, and especially protecting people who might be vulnerable.
For sure. It's about making sure the will really reflects what the person wanted.
Awesome. That covers intention. So we've got capacity, intention, and now our third pillar, which might be the most detail-oriented one, formal requirements. And this is where the Wills Act from 1837 really comes into play.
Yeah, this is where it gets nitty-gritty.
Super specific. So what's the big idea here?
Well, the crucial thing about these formalities, the rules set out in Section 9 of the Wills Act, is that you absolutely have to follow them to the letter. No cutting corners. Even if you have capacity, even if your intentions are crystal clear, if you mess up the formalities, the whole will could be thrown out.
Wow. So even with all the right intentions, you got to dot your I's and cross your T's?
Absolutely. No room for error here. So the first big requirement is that the will has to be in writing.
Okay, so no verbal agreements or, videos?
Nope. It's got to be written down, handwritten, typed, printed. It doesn't matter. Yeah. But it's got to be clear and unambiguous.
Makes sense. Less room for interpretation that way. So, writing, check. What's next?
Next up is signing. The testator, the person making the will, has to sign it. Or someone else can sign it on their behalf, but it has to be in their presence and with their specific instructions.
Okay, so there's a bit of flexibility there, but still very controlled.
Right. And ideally, that signature should be at the very end of the will. That prevents anyone from adding stuff later on that wasn't properly witnessed.
Smart move. Okay, signing. Check. Now, the part we always see in the movies, the witnesses.
Right. Witnessing is key. The testator's signature has to be witnessed by at least 2 people, but not just anyone. They have to be competent witnesses.
Meaning?
Well, they have to be of sound mind, just like the testator, and they have to be at least 18 years old.
Okay, so adults who understand what's going on.
Precisely. And here's the catch. Neither of the witnesses or their spouses can be beneficiaries in the will. You can't witness a will where you're getting something.
Oh, wow. So, you can't have your best friend who's inheriting your vintage record collection also be a witness?
Nope. If they are, they lose their inheritance, though the will itself might still be valid.
Okay, that's a good one to remember. And they don't just sign anywhere, right? They have to be there when the testator signs.
Exactly. Physically present. And not just in the same room. They have to be able to actually see the testator signing or acknowledging their signature.
So line of sight is important.
Crucial. And they have to be aware of what's happening. They don't have to read the will or know what's in it, but they have to know that they're witnessing a signing. And then Each witness signs the will too, and that has to happen in the presence of the testator.
Okay, so it's a very specific choreography.
It is. A lot of rules.
Now, our sources mention that during COVID, there was a temporary change to the rules about witnessing. Something about remote witnessing.
Yeah, the government made a temporary change to the law,
Yeah.
allowed for witnessing through video calls.
Oh, wow. So that's pretty significant.
It was, yeah. But it was only for a specific period, wills made from January 31st, 2020 to January 31st, 2024.
Okay, so that window has closed.
It has. And there's another important thing to note, that remote witnessing, it wasn't allowed if someone was signing the will on behalf of the testator.
So even with the temporary rule change, there were still strict limitations.
Always. Now, there's also this thing called an attestation clause that's really important.
Attestation clause. That sounds very legal.
It is, yeah. It's basically a statement at the end of the will that confirms all the formalities of signing and witnessing were done right.
So like a checklist to say, yep, we did everything by the book.
Exactly. And it usually says something like, the will was signed by the testator in the presence of two witnesses, who then also signed in the presence of the testator and each other.
So very specific.
Very. And while a will technically isn't automatically invalid if it doesn't have an attestation clause, missing it can raise doubts about whether everything was done correctly.
So it's like asking for trouble.
It can be, yeah. Might lead to disputes, needing more evidence to prove the will is valid. So best practice is to always include it.
Makes sense. Better safe than sorry, especially with something this important.
Absolutely. Now, there's another specific rule to keep in mind if a solicitor is named as a beneficiary in the will.
Oh, interesting. Why is that?
Well, it's all about preventing conflicts of interest. Making sure the person making the will isn't being taken advantage of.
Right, because a solicitor, they have a duty to act in their client's best interests.
Exactly. So if a client wants to leave a significant gift to their solicitor or someone close to them, the solicitor should really advise them to get independent legal advice.
So like a second opinion to make sure everything's on the up and up.
Exactly. Otherwise, it could look like there was some undue influence happening.
Right, it's all about transparency and protecting the testator. Now, even if a will looks perfect on paper, all the I's dotted, subtle I's crossed, formalities followed, there can still be reasons why it might be challenged. And those reasons often come down to the circumstances surrounding its creation. And that brings us to duress and undue influence.
Yeah, these are big ones.
Like serious grounds for contesting a will.
Absolutely. Because both duress and undue influence, if they're proven, they can make a will invalid.
And the reason for that is?
Well, the whole idea of a will is that it's supposed to be the free and voluntary expression of what the person wants. But duress and undue influence, they interfere with that freedom.
Okay, so let's unpack this. What exactly is duress?
Duress is basically when someone is forced to make a will against their will because they're afraid.
Afraid of what?
Well, it could be a threat of physical harm, damage to their property, or even some kind of serious psychological pressure.
So, like being blackmailed into making a will.
Exactly. But to actually prove duress, you'd have to show that the threats were real, that they actually made the person scared, that it was a fear that would overcome someone with normal courage, and that it was the specific reason why the will was made the way it was.
Okay, so a pretty high bar to clear.
Very high. And then there's undue influence, which we touched on a bit earlier.
And that's the more subtle one, right?
Yes, it's more about manipulation.
Yeah.
Someone putting excessive pressure on the person making the will, using persuasion or even deception to get them to do what they want.
So like not outright threats, but still not really their own free will.
Exactly. The key is the influence has to be so strong that it overpowers the person's own judgment and free will. Just giving advice or suggesting things, that's not enough. It has to cross the line into coercion.
Okay, so there's a difference between like helping someone understand their options and pushing them into something they don't really want.
Exactly. And if undue influence is proven, the will becomes voidable, meaning the person who is pressured or their representatives can choose to have the whole will thrown out.
Wow, so it's like it never existed.
Right. Now, our sources bring up this old case, Wingrove v. Wingrove, from 1885, to illustrate undue influence.
And what's the takeaway from that case?
Well, Wingrove v. Wingrove is important because it makes it clear that to prove undue influence, you have to show that the person making the will was basically forced to act against their own wishes.
So not just that someone had the chance to influence them, or even that they did influence them a little bit.
Right. It's about proving that their free will was completely overridden.
Okay, so that's duress and undue influence. Now, what happens if someone makes a will, everything's legit, but then they change their mind? Life happens, circumstances change. What are the rules around changing or completely getting rid of a will?
Good question. The good news is you can always change your mind about your will, as long as you have the mental capacity to do so.
Right, so that capacity thing, it's important from start to finish.
Absolutely.
Yeah.
Now, when it comes to changing a will after it's already been signed, things get a little tricky. The Wills Act of 1837, specifically Section 21, has very specific rules about this.
Okay, lay it on me.
Any changes you make after the will is signed, they're only valid if they're done with the same formalities as the original will. Signed by the testator, witnessed by two people,
Yeah.
the whole 9 yards.
So basically, you're treating the changes like a mini will.
Yeah, exactly. And if a change isn't done properly, then the original wording of the will stays in place. But only if you can still read it. If the original words have been crossed out or scribbled over so they're impossible to read, then those words are considered revoked, like they were destroyed.
So it's like they were never there.
Right. Which is why messing around with your will can be a recipe for disaster.
Totally. It's like creating a legal puzzle that no one can solve.
Exactly. Now, luckily, there's a much easier way to make changes after a will is done. It's called a codicil.
A codicil.
Yeah, it's basically a separate document that amends your existing will, but it doesn't replace it entirely. Think of it like an addendum or a modification.
Okay, so not a whole new will, just some tweaks here and there.
Right. And codicils are usually used for smaller changes, like adding or removing a specific gift, changing an executor, updating a beneficiary's info, things like that.
So when would someone choose a codicil over just making a whole new will?
Well, if you just need to make a few simple changes, a codicil is definitely the way to go. It saves you the hassle of rewriting the whole will.
Makes sense. Like, if you just want to add a gift for a friend or switch up one of your executors, no need to start from scratch.
Exactly. But our sources are pretty clear about this.
Yeah.
If you've got lots of changes to make, or they're big, major changes, it's usually best to just create a whole new will. Too many codicils, it can get confusing.
Right, it's like having too many cooks in the kitchen.
Exactly. Now, speaking of starting fresh, let's talk about getting rid of a will entirely, like hitting the reset button.
Revoking it.
Right. And the good news is, if you have the mental capacity, you can revoke your will anytime before you die. No questions asked.
Okay, so full control as long as you're, mentally there.
Exactly. And there are a few ways to do it. The most straightforward way is to just make a brand new will that explicitly says it cancels out all the old ones.
So the new one supersedes the old one.
Yep. No more confusion about which one's the real deal. Another way is to physically destroy the will.
Like burn it, shred it.
Yep, that'll do it. But, and this is important, you have to destroy it with the intention of revoking it. If you accidentally spill coffee on it, or your dog eats it, that doesn't count.
Okay, so it's not just about the physical act, it's about the intention behind it.
Exactly. Now, remember those invalid alterations we talked about earlier?
The ones that aren't properly signed and witnessed.
Right. Well, if those alterations involve completely obliterating the original wording to the point where it can't be read, then those words are essentially revoked, even if the rest of the will is still valid.
So it's like a weird side effect of messing with the will.
It is, yeah. Another reason to just do things properly in the first place.
Totally. Now, there's also this thing called revocation by operation of law. What does that mean?
That's when the law automatically revokes a will because something major happened in your life. And the biggest example of that is marriage.
Oh, wow. So getting married can actually invalidate your will.
It can, yeah. Under the Wills Act, if you get married, any will you made before the wedding is automatically revoked unless it specifically says it was made with that marriage in mind.
Wow. Okay. So if you write a will as a single person and then get married, that old will is basically useless unless it specifically mentions that you were planning to get hitched.
Exactly. And it has to be super clear. It can name the person you're going to marry or even just say you're planning to marry without naming them, but that intention has to be in the will itself.
Okay, so no vague hints about future love. It has to be spelled out.
Yep, crystal clear. Now, here's a fun fact. The law doesn't usually let you make an irrevocable will. One that can't be changed.
No, really. So you always have the option to change your mind.
As long as you have the capacity, yeah.
Yeah.
You can always revoke or change your will. Now, there's also this thing called mutual wills, where two people basically agree to make similar wills and promise not to revoke them. And that could create some legal complications, like a constructive trust, if one person tries to back out after the other one dies.
Okay, so that sounds like a whole other deep dive.
It is, yeah. Lots of nuances there. Now, what about divorce? That's another big life change. What happens to a will then?
Yeah, good question.
So divorce, or ending a civil partnership, it's a bit different from marriage. It doesn't automatically revoke the whole will, but it does treat your ex-spouse or partner as if they died on the day your divorce or dissolution became final.
Oh, wow.
Yeah. So if you name them as an executor or trustee in your will, that's no longer valid. And any gifts you left them, those are gone too. Unless, of course, your will says something different.
Okay, so it's like they're written out of the will.
In a way, yeah. And it's important to remember, this only applies to legally finalized divorces and dissolutions. Just being separated, even with a court order, doesn't have the same effect.
Okay, so you need that legal finality.
Exactly. So just to sum up some of the key things we've covered. To have a valid will, you absolutely need testamentary capacity, that specific legal and mental understanding we talked about at the moment you create the will. You need to genuinely intend for that document to be your will. And you have to follow all the formal requirements of the Wills Act, like it being in writing, signed correctly, and properly witnessed.
Right, so those 3 pillars are non-negotiable.
Exactly. And even then, there can be other things that invalidate a will, like duress or undue influence. And then you've got life events like marriage, which usually revokes a prior will, and divorce, which has specific rules about how your ex is treated. And remember, any changes you make after your will is signed, those have to follow strict procedures too. Codicils are a good way to handle smaller amendments.
Awesome. So lots to think about. It really makes you realize how many wills out there might not actually be valid, or maybe they don't reflect what the person really wanted anymore.
Yeah, it happens more often than you'd think.
And it really highlights the importance of not only making a will, but also checking it regularly, making sure it's up to date, and maybe even talking to a legal expert to make sure everything's good to go.
Couldn't agree more. It's worth taking the time to get it right.
Absolutely. After all, it's about making sure your wishes are carried out.
Exactly. And that's what matters most.
Totally. And on that note, it makes you wonder how many people out there might be walking around with a will that's essentially a ticking time bomb. You know, something that seems fine on the surface, but could cause a whole lot of problems down the line. Something to ponder.
Food for thought, for sure.
Definitely. So thanks for joining us on this deep dive. And until next time, stay informed and stay empowered.
Thanks for having me.